I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Monday, September 29th, 2025. The time is 12:20 in the afternoon, and we are holding this public hearing in room 412 of the John A. Wilson Building. The subject of this hearing is Bill 26-175, entitled the Uniform College Athlete Name, Image, or Likeness Act Amendment Act of 2025. This legislation was introduced by me on Friday, March 14th, 2025, at the request of the Uniform Law Commission. And in a word or two, if I can find my notes here, what this legislation does is to make a slight amendment to the Uniform Act regarding college athlete name, image, or likeness law to try to keep up with the changing situation with regard to collegiate sports. And I think I'll leave my explanation with that. The record in this matter will be open for 2 weeks. Give me a second. I could do a little better. The amendment would authorize institutions, athletic conferences, and associations to assist college athletes in selecting, coordinating, or compensating a name, image, or likeness agent. Additionally, the bill eliminates the current prohibition that prevents institutions or conferences from providing direct compensation to college athletes for the use of their name, image, or likeness. The district's original name, image, likeness law was modeled on the NCAA bylaws in place at the time of enactment, which predated both the adoption of Article 22 and the commencement of litigation entitled the House litigation. The proposed amendment aligns district law with the current NCAA framework and national legal landscape, ensuring that institutions and college athletes in the district are not placed at a competitive disadvantage. This legislation actually is in effect already because we've adopted an emergency version of it. But if we like it, then we should make it permanent, and that's what this Bill 26-175 is all about. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on Monday, October 13th, 2025. Anyone wishing to submit additional comments or who isn't commenting and wishes to comment has 2 weeks, again, till the close until 5 p.m. on Monday, October 13th, 2025. I have 4 witnesses on the list, but I don't think I have 4 people present. Michael Lippitz, Associate Vice President and Director of Athletics at George Washington University. Why don't I start with him, and then I'll ask Libby Snyder from the Law Commission, Uniform Law Commission, and Brian Flowers if they would come forward after we're done with Mr. Lippitz. Mr. Lippitz, you're up.
Thank you and good afternoon, Chairman Mendelson and members of the Committee of the Whole. My name is Michael Lippitz. I have the privilege of serving as the Associate Vice President and Director of Athletics at the George Washington University. On behalf of our student athletes, coaches, and staff, thank you very much for the opportunity to testify in support of making permanent the Uniform College Athlete Name, Image, and Likeness Temporary Amendment Act of 2025. Over the past several years, as was just noted, the landscape of college athletics has undergone transformational change. Student athletes now rightfully can benefit from the use of their name, image, and likeness, their NIL, and share directly in athletically generated revenues following the NCAA's settlement of the House case. This legislation is essential to ensure that student athletes at universities here in the District of Columbia, including GW, are provided the same opportunities, protections, and support for NIL activities that are afforded to their peers across the country. At GW, we sponsor 400 student athletes across 20 NCAA Division I programs, and we're charter members of the Atlantic 10 Conference. Our student athletes proudly represent the district across the DMV and on the national and global stages. Our athletes and teams bring positive visibility to our city through their success in competition, in the classroom, and throughout our community. To remain competitive and to deliver on our mission of supporting our young people, we must have the continued ability to provide them with comprehensive NIL education, support, and the ability to participate in direct revenue sharing that is now effective nationally. At this past September legislative meeting, the council passed a first vote on Bill 26-119 that would designate the District of Columbia as the official sports capital of the United States and would require Events DC to develop a plan to promote, support, and enhance the district's status as the nation's premier destination for sports events, teams, and activities. By supporting our universities and student athletes through the passage of this legislation, the council strengthens DC's sports ecosystem and our collective opportunity to attract world-class events. If the temporary amendment is not made permanent, student athletes at GW and all DC universities would be placed at a competitive disadvantage relative to their peer institutions in neighboring states and across the country. It would restrict current and future financial opportunities for student athletes who choose to attend school in DC and would undermine universities' ability to recruit and retain outstanding student athletes to represent our city. Our student athletes invest so much of themselves representing GW and the District of Columbia with pride. They do deserve the same opportunities, support, and benefits their peers are receiving at universities in Maryland, Virginia, and across the country. I thank you for your leadership on this issue and your commitment to advancing higher education and intercollegiate athletics in the district, and respectfully urge you to make permanent the Uniform College Athlete NIL Amendment Act to keep Washington, D.C. at the forefront of supporting and empowering student athletes. Thank you again for your time.
Thank you, Mr. Libetz. I have just a couple of questions for you. One of them is, I don't think I have a copy of your statement, if you could provide that.
I'll be glad to.
Thank you. And second, one of the concerns we've had with name, image, likeness, which is why we adopted the uniform law, was to protect athletes, college athletes, from exploitation. In your experience at GW, has there been any risk of that or any instances of that?
I haven't seen instances of exploitation, but I do think it bears keeping in mind, particularly as related to some of the exorbitant fees that we've seen agents charge around the country. I think that's a particular point to make sure that our student athletes are educated, informed, to make good decisions in terms of who they select to represent them.
And in your experience at GW, to what extent are college athletes taking advantage of name, image, and likeness opportunities?
We have dozens of student athletes at GW who are taking advantage of these opportunities. Some now with our support, since we can now provide that kind of support, some independently. But as was noted, it's wide open now, and we have many student athletes who are increasingly showing interest in capitalizing on the opportunities that they heretofore have not had.
So of the lesser known athletes, what kind of NIL options are available? Are they taking advantage of?
Really anything.
Actual experience.
Yeah, a number of our Olympic sports student athletes, the non-revenue student athletes, have taken advantage of opportunities with local businesses, with social media campaigns and companies to help promote their products. Really, the opportunities are limitless, and it's more a factor of any individual's willingness to devote the time and invest the time necessary to capitalize and profit from their name, image, and likeness.
Give me just a second. I don't have any other questions for you. Again, give us a copy of your statement if you would, please. And thank you for taking the time to testify. Nope. I'm sorry, hold on, don't go anywhere. And I didn't recognize you for an opening statement. Councilmember Felder, the floor is yours.
I'll go with the opening statement.
Do both. Don't go anywhere, Mr. Libetz.
Thank you, Mr. Chairman. Good afternoon, everyone. I'm excited to speak about making permanent Bill 26-175, the Uniform College Athlete Name, Image, or Likeness Act, Amendment Act of 2025. As many of you all know, the District of Columbia as a whole, but particularly Ward 7, is home to an incredible number of talented young athletes. From our neighborhood recreation leagues to our high schools, I have a firsthand understanding of how much time, effort, and energy that so many of our young people put into becoming world-class athletes. And as a former college athlete myself, I can also attest to the sacrifices athletes make in order to compete at the highest level. For far too long, universities have made billions of dollars on the backs of our student athletes, particularly athletes of color. This bill is about correcting that imbalance. When you're good at something, when you dedicate your energy and talent to perfecting your craft, you should be compensated. This legislation makes it clear that student athletes should have the same basic right as everyone else, the ability to control and benefit from their own image and hard work. I'm glad to see the district moving in the right direction. Laws like this make it not only better for athletes of today, but also for tomorrow. The young people all across the district who dreamed of playing at the college level or even becoming professional athletes will know that if they choose to go to a university here in the district, they will be protected and supported. I'm looking forward to uh, individuals who signed up to testify today, and I want to thank everyone for their time. And with that, just keeping things along with the chairman, just a couple of questions for you. Uh, you mentioned support. Could you speak to what support consists of? Like, is there a dedicated person at GW? Do students work with the athletic department? What does support look like for the normal student athlete who wants to, you know, who wants their likeness and image, and who wants to be compensated for their likeness or image?
Thank you for the question. We have several staff that support in this area, primarily out of our student athlete development unit. Support can take many forms, but often looks like education in terms of what the NIL opportunities are, connecting with our current and potential corporate partners to provide those connections and opportunities for student athletes to capitalize on their NIL. It can also take the shape of financial literacy education so that our student athletes know what the contracts that they're asked to sign are all about and can make informed decisions. And for our basketball programs in particular, we, along with a number of programs across the country, with a focus on basketball as our flagship, have a general manager in the space that works directly with our men's and women's basketball student athletes, given their high profile, to help them navigate these opportunities. So we try to provide comprehensive support and are continuing to build out in this space as these opportunities present themselves in support of our student athletes.
Thank you for that. I appreciate the support that your university is providing our student athletes. And could you speak to the process, right? Like, is this an annual thing? Say, if I want to, if I want to allow my likeness to be provided, is there like a gap in which you have to register after, say, basketball practice or track practices? Are coaches promoting this? What's the normal process?
It really depends on the company or the entity that the student athlete is looking to contract with. Some of these are short-term deals. Other times they could be multi-year deals. It really depends on the product or the company and what they're looking for from the student athlete in order to be able to monetize, or to achieve their purpose in the marketplace. It runs the gamut in terms of the duration of the contracts and when they start and when they end.
Thank you. And then my final question, you mentioned you have about 400 athletes. I'm optimistic that the district will make this permanent, but in the event that it doesn't, could you speak to some of the competitive disadvantages?
Sure. Given that we have dozens of student athletes currently taking advantage of these opportunities, were this not to be put into effect permanently, certainly those student athletes could look to transfer, as is their right, to take advantage of the opportunities elsewhere, and we could have a real talent drain from not just GW, but from all of our universities in the district as student athletes pursue these opportunities at schools outside the district that in all the jurisdictions that currently allow this.
Thank you for that. Mr. Chairman, that concludes my questions.
Thank you. Thank you, council member. And again, thank you, Mr. Lippitz.
Thank
I'm now
you.
going to call Libby Snyder, Special Counsel with Uniform Law Commission, and Brian Flowers, DC Uniform Law Commissioner. And Mr. Flowers, you're sort of filling in for Jim McKay, who we were originally expecting and usually testifies. So we'll try to be nice to you, since you're the trying to think of the I'll think of the word in a second. Since you're the backup, we'll be nice to you. When you're ready, where's Miss? Oh, there's Miss Snyder's online. Okay. Miss Snyder, you want to go first?
Sure, thank you. Good afternoon, Chairman Mendelson and members of the Committee of the Whole. My name is Libby Snyder, and I am Special Counsel at the Uniform Law Commission. Thank you for giving me the opportunity to speak briefly on the Uniform College Athlete Name, Image, or Likeness Act as adopted by the district and Bill 26-175 to amend that act. The Uniform College Athlete Name, Image, or Likeness Act, or UCANLA, was drafted by the Uniform Law Commission in 2021 with the goal in mind to allow college athletes to earn compensation for the use of their name, image, or likeness, while also providing reasonable protections to educational institutions, athletic associations, and conferences. When the Uniform Law Commission drafted UCANLA, the National Collegiate Athletic Association, NCAA, bylaws still prohibited college athletes from receiving compensation for the use of their NIL, which left college athletes vulnerable to disciplinary actions or even a loss of athletic eligibility if they attempted to engage in NIL activity. Right before the finalization of UCANLA by the Uniform Law Commission, the NCAA issued a new interim NIL policy that permitted college athletes to engage in NIL activities consistent with the law of the state where the school is located. And it also allowed college athletes who attended a school in a state without an NIL law to engage in NIL activity without violating NCAA rules relating to NIL. Under the interim NIL policy released on June 30th, 2021, institutions that were located in states without NIL laws were given permission to create their own NIL policies as long as the policies prohibited NIL compensation to be used for pay for performance or as a recruiting inducement. When the ULC drafted UCANLA, we sought to provide comprehensive, uniform state-level framework for the regulation of NIL activities and wanted to give robust protections to both the educational institutions and the college athletes. But as discussed previously, the landscape has changed significantly since the ULC drafted UCANLA, and these amendments to district law are necessary to ensure that college athletes and universities in the district are not at a competitive disadvantage. Those changes were brought about by amendments to NCAA bylaws, adding Article 22 to the NCAA bylaws, which give educational institutions the ability to provide certain assistance and services to college athletes pursuing NIL opportunities that are currently prohibited under district law prior to the enactment of the temporary amendment. And then the House v. NCAA settlement, which gave the ability for educational institutions to provide direct payments to college athletes for the use of the college athletes NIL. So as discussed previously, these amendments to district law are necessary to ensure that universities and college athletes in the district are not at a competitive disadvantage, and the Uniform Law Commission supports these amendments. Thank you.
Thank you, Ms. Snyder. Mr. Flowers.
Thank you, Mr. Chairman. Chairman Mendelson and members of the committee, good afternoon. I'm Brian Flowers, District of Columbia Uniform Law Commissioner, and I'm appearing on behalf of James McKay, who's the chair of our commission and who is unable to appear today. I appreciate the opportunity to appear before you to testify in support of Bill 26-175, the Uniform College Athlete Name, Image, or Likeness Act, Amendment Act of 2025, which would amend the Omnibus Uniform Athlete, Agent, and College Athlete Name, Image, or Likeness Act of 2022. As Libby, I think, pronounced it UCANLA. It's the acronym. And this would authorize institutions, athletic conferences, and athletic associations to assist college athletes in activities related to the monetization of their name, image, or likeness, often abbreviated as NIL for our purposes of the DC's NIL law. Specifically, the amendatory bill would permit colleges to assist college athletes in selecting, arranging for, and providing payment to an NIL agent, and in selecting, arranging for, or collecting payment from a third party engaged in specific NIL agreements with a college athlete. The bill would also eliminate the problematic or the prohibition on direct compensation by institutions or conferences to college athletes for the use of their names, images, or likenesses. As discussed, the bill would enact as permanent law amendments to our NIL law that the council recently has enacted as emergency and temporary legislation. This responds to a dramatic shift in policy by the NCAA, is reflected in its settlement of a federal antitrust class action lawsuit. When the UCANA, the district's NIL law, was drafted by the Uniform Law Commission, the NCAA's bylaws prohibited college athletes from receiving compensation for the use of their name, image, or likeness. This made college athletes vulnerable to disciplinary actions or loss of athletic eligibility if they attempted to engage in NIL activity. Once we became of the NCAA's change, we brought the legislation to the council, and the council acted swiftly. So as a result of the enactment of NIL laws by many states, the NCAA amended its bylaws, which allows the activity that this amendment is now permitting. So as a result, amendments to district law are needed, and we urge you to take full advantage of the policy change and enact permanent legislation. Libby and I are here to respond to any questions you might have.
Thank you, Mr. Flowers. Thank you, each of you. So I'll start with this. How many states have adopted the uniform bill? And I'm talking about the uniform bill that came out in 2021.
The district is the only jurisdiction that adopted the Uniform Act, because by the time the Uniform Law Commission finalized drafting, so many states had acted in various different ways and were no longer interested in uniformity.
Which could be a problem.
Mhm.
So then if I ask how many states have adopted the amendment, the answer would probably be 0, because this is only for us.
That's correct.
Does the commission, meaning the Uniform Law Commission, are you aware of reported cases where there's been exploitation?
I'm not directly aware of any reported cases where there's been exploitation with respect to college athlete name, image, or likeness. When this was enacted in the district, it was enacted alongside the revised Uniform Athlete Agents Act. And there are cases in the past with athletic agents exploiting relationships with college athletes and getting them to sign contracts that were exploitative because they were taking advantage of the imbalance of power between a 18-year-old college athlete and themselves an experienced athletic agent. But with respect to UCANA or NIL activity, I'm not directly aware of any exploitation.
Okay. This is a question I did not expect, and that is whether this issue of NIL and what we're doing with uniform law affects international student athletes who may face visa restrictions on earning income. Do you know?
That was not an issue that the drafting committee considered when drafting UCANA. However, I will note that both UCANA and the district's enactment of the law does give institutions, conferences, and athletic associations the directive to educate college athletes about NIL compensation by offering financial literacy and life skill programming. And it it could be that that programming might include information directed towards international students. I know that there's an introduction to income taxes that's suggested as programming in that mandate, but I'm not aware of anything specific.
All right, thank you. Give me a second here. Have you seen any instances where this new, I guess I'll call it phenomenon of compensating athletes or paying athletes for their NIL? Have you seen any instances where that has created some hardship for higher institutions of higher education?
I think that it has just changed the playing field completely in what institutions are used to and what they were expecting. Since the beginning of the NIL era in 2020 to now, with the changes to NCAA policy, different state laws, how institutions are handling it, NIL collectives, I think that the hardship could be that there's just so much shifting and changing that policies are constantly needing to be updated and changed to comply with litigation and NCAA rule changes, which was one of the goals of drafting UCANALA. Another hardship could be, providing oversight. I know that some states will require the athletes to submit very long disclosures about the contracts. UCANALA only required those disclosures if it was above a certain amount. And so I think that could also be considered a hardship under this type of activity.
Any effect on Title IX compliance? I would think not, but I want to ask.
None that I'm aware of.
I don't have any other questions for you. I don't have any other questions for you, Mr. Flowers.
Thank you, Mr. Chairman. Appreciate that.
Thank you. As I indicated at the beginning, the record in this matter will be open for 2 weeks, and then we'll proceed to markup after that. So I want to thank each of you, and I want to thank all the witnesses and anyone else who submits comments.
Thank you very
With that,
much.
The time is 12:48 p.m. and this hearing is adjourned.